Hello and welcome to this video about citizenship. It's a substantive video, so we'll get to talk about everything you need to know for your test. And I'm going to give you a little introduction and then I'm going to talk about Article 20 and 21. And we're also going to talk about the CRD, so the Citizens' Right Directive. And we always use that directive in combination with Article 21 of the TFEU. Never with 20, that's a no-go, but always with 21, because CRD, the Citizens' Right Directive, is a lex specialis, so it extends the rights of 21, but never with 20. Don't make that mistake on your test. So first, a little introduction. If you're an EU citizen, or I have to say you're a citizen of an EU member state, like me, I'm a citizen from the Netherlands, then you automatically get EU citizenship. So that's automatically, it's additional and it's followed by law. If we look at the TFEU, we see that in Article 20, formally your EU citizenship is established. And in Article 21, you get the right to reside and move freely throughout the whole EU. And then we also have the secondary legislation, which I just talked about, the Citizens' Rights Directive, or the CRD. Hopefully I will be calling it the whole video that, because it's such a long term, but it extends the free movement rights to EU citizens, their family members, EU workers, job seekers, students, and self-sufficient individuals. So then you have then you have enough money to be able to take care of yourself. And some restrictions can be allowed, like on grounds of public policy, security, and health concerns, but it has to be objective and it has to be proportionate. So CRD is an extent to Article 21, and it's a lex specialis. So always use it in combination. That's very important to note for yourself and not do that wrong on your exam. First, the right of residence, Article 20 TFEU and the CRD. We're also going to talk a little bit about that directive, but don't get wrong that you need to use them together. So we're talking about the right of residence, Article 20 TFEU, and we're talking about the Citizens' Right Directive. So we have the derived right of residence, or it's called the derived right of residence. And in Dutch, that's het afgeleide verblijfsrecht van iemand. And the person that has that derived right of residence, it's probably a third country national. So third country national is someone who has who does not have an EU citizenship, but they're linked to someone who does have that EU citizenship. And mainly we're talking about the case that we are dealing with a parent and we're dealing with a child. And the child has EU citizenship, but the parent does not have EU citizenship and obviously wants to stay with the child within the EU. If we're looking at Article 21 and then we're automatically looking at the CRD, then the first thing you need to do when you're actually on a test, I'm sorry, said that a little bit wrong, but if you're on a test and you see that the case is about citizenship, then you need to be able to make a roadmap, a stappenplan. You need to take certain steps and then you will be able to get to the right answer, but you get the points for the roadmap, obviously. So first, always look if you're not dealing with Article 21 and the Citizens' Right Directive, because you're only going to Article 20, if we're not dealing with 21. So always first look at Article 21. That's the main legal basis. We're only going to 20 if we're not dealing with those two. So that's step 1. Step 2 is to look if we're actually, and that is a little bit with step 1, it goes together, because the difference between 21 and 20 is that with 21 we're dealing with a cross-border element. We're dealing with someone going over borders. With 20 we're not dealing with a cross-border element, so we're probably dealing with the situation that we have a mother or a father and a child, and they're staying within the EU, but they have the danger that they have to leave the EU because they are third country nationals, but the child wants to stay within the EU. So that's mainly the case they are giving you on the exam. So they are not wanting to move. There's not a cross-border element because they're not moving right now. They're not going to move, but the case is like, okay, maybe if you're not granted that derived right, dat afgeleide recht, then you will get a cross-border element, of course, because then you need to leave the country, you need to leave the EU. But like in beginning, there is no cross-border element because everyone wants to stay just in place. When we're dealing with Article 21, we're dealing with a cross-border element. So that's the difference. So that's a little bit like step 1.5 or 2. We're deciding if we're dealing with Article 21 or 20 by stating if we're dealing with a cross-border element. And we have a really, really important case, and I hope you're going to highlight every paragraph that I put on the slide, because this is the most important case, and you will be lost if you don't have this case with citizenship, because you're going to get so many answers out this case. It's the Chavez-Vilchez case, and it's about the right of resident of a third country national. It's step 3 if we decided we're dealing with Article 20. And this case was, well, in the introduction I talked about the case like what it was about, but like in short, it was about 8 women, and one of the women was Chavez-Vilchez, and she had a Dutch child. Well, the child had a Dutch nationality and an EU citizenship. So the mother was actually a third country national, and there was speaking of the fact that she needed to leave the country and the EU. But if you take the mother away, then probably you have to take the child away. And in paragraph 65, the court stated that you actually cannot take the child his or hers genuine enjoyment of substance, because the child is actually an EU citizen. So the child has the rights, the EU rights, and the enjoyment of those rights. And the court stated, yeah, you have that citizenship and you can't be just taken away from that enjoyment just because your parents are third country nationals. Paragraph 68 and 69 talk about the relevance of custody and dependency. So if you're on the exam and you get a case about Article 20, we're dealing with a third country national parent and we're dealing with a child that has EU citizenship, then you have to look at the relationship between the child and the mother or the father, the parent. You have to look how dependent is this child on that specific parent. And in paragraph 70 we see that actually we're dealing with the Charter of Fundamental Rights of the EU, because Article 7 is about the right to respect family life. And to respect family life, you obviously don't take away the mother from a child. So paragraph 71 again states that we really have to look at that relationship of dependency. So how dependent is the child on the parent that maybe has to leave the EU? We're going to look at different factors. We're going to look at age. We're going to look at emotional and physical development and the risk of separation. What would happen if we indeed take the mother away from the child? So is there another parent that maybe could take care of the custody? Is that a really weird step? Because if we're, in this case, in Chavez-Vilchez, there were actually fathers and the fathers had EU citizenship. But the mothers had the primary custody. So it's really weird just to say to a child, well, your mother is a third country national, your father has EU citizenship, so from now on you're just going to live with your father. That's not something we're able to do, and definitely not compatible with Article 7 of the Charter of Fundamental Rights. So I really advise you to look in our summary and just really take this case, like give it a good look and highlight the important part in your readers. So highlight 65, 68, all the paragraphs I put on this slide, and then you will be able to give a full answer on your test. European citizenship, Article 21 of the TFEU, and it also applies to migrant non-economically persons. So I'm going to zoom in this slide as well because it's a really full slide. We actually have a roadmap we're going to deal with, so we need to take certain steps to get to an answer. First, we need to look at the applicability of EU law. Are we even dealing in this case with EU law? And then we have to look at two things. We have to look at the personal scope and we have to look at the material scope. The personal scope is, okay, are we talking here about an individual that has the nationality of an EU member state? Or when we're talking not about a person, then we're probably talking about an entity, or maybe a company. Is the corporate seat located in an EU member state? But I probably think if you get this on a test, that we're talking about an individual. But for the full picture, if we're talking about an entity, for the personal scope, we need the corporate seat to be located in an EU member state. Then we have the material scope. And we need a cross-border element. As I stated before, when we're dealing with Article 21, we always need a cross-border element. So something needs to go from member state A to member state B. We also sometimes, when we're dealing with EU law, we almost always need an economic activity. But with Article 21, with citizenship, it's a bit different, because we actually saw that the court became more relaxed with this and that it actually extends to individuals who are not economically active. So we see it in the title. It also applies to migrant non-economically persons. So you don't need to be a worker to be able to invoke your rights based on Article 21 of the TFEU. So it's an element we're almost always dealing with within when we're talking about EU law and economic activity, but explicitly it extends to individuals who are not economically active. So remember that. If we indeed stated, okay, we're dealing here with an individual, nationality of an EU member state, we have a cross-border element, something is going from A to B, then we're going to step 2 and we're looking at the applicability of the Citizens' Right Directive. Because I told you, if we're looking at Article 21, we're automatically looking at CRD. It's a lex specialis, it extends the rights of Article 21. So always see if also the CRD applies. Okay, so we're dealing with Article 21, we're looking, okay, can we extend the rights of Article 21? How do we test that? Well, we see in Article 3, paragraph 1 of the CRD, that it applies to all Union citizens who move to or reside in a member state other than that of which they are a national, and to their family members as defined in point 2 of Article 2 who accompany or join them. So that is when the CRD applies. Then in Article 2 and then paragraph 1 and 2 of the CRD, we see a definition, because we see a definition of a Union citizen. So who is a Union citizen? Well, it's any person having the nationality of a member state, so that's quite logic. And Article 2, paragraph 2 gives the definition of a family member. So we see in the definition that it also extends to family members as defined in point 2 of Article 2. Well, the family members are the spouse, the partner in a contracted registered partnership, and the direct descendants. So that's what we're talking about when we're dealing with family members. So always check the CRD. Okay, it applies to Union citizens and their family members, but are we dealing with someone who is falling under the definition of family members? So that is that for the applicability of the Citizens' Right Directive. If you stated, okay, we're dealing indeed with the Citizens' Right Directive, then we're moving on. We're going to step 3, which right is actually being claimed, because we're talking about 21, but are we talking about the right of residence, so een verblijfsrecht, or are we talking about the right to equal treatment, dus gelijke behandeling? Well, I'm going to zoom in again. When we're talking about Article 21, we have 2 rights that can be claimed or invoked. And that's the right of residence and the right to equal treatment. And it's very important to make a distinguishment. So Article 21, the right of residence. We see if you're here as an individual less than 3 months, that you're based on Article 6, paragraph 1 of the Citizens' Directive, you need a passport and you need health insurance. That's the only 2 things you need. So that's quite a low bar. If you're between 3 and 5 months and 5 years, we need a little bit more. So then we also look in the Citizens' Right Directive. We look in Article 7, paragraph 1a and b. We see that workers and self-employed people have the right to reside. So if you are a worker and someone is your boss, you're just working with a company, you have the right to reside based on Article 7, paragraph 1a of the CRD. But when you're not a worker and you're not self-employed, so you also don't have a company yourself, then we're looking at B, and you're not involved in an economic activity, as I stated before. When we're dealing with 21, just look where the right slide is here. When we're dealing with 21 and we're looking at the material scope, we don't explicitly need an economic activity, because it extends to individuals who are not economically active. So we are also dealing with migrant non-economically persons. But there's something we need if we're dealing with someone who is not involved in an economic activity. We need sufficient resources. So we need someone who's able to take care of themselves. And if you're longer there than 5 years, then you get the permanent right of residence. So you have a really stable position right then, actually, if you have stayed longer than 5 years in the same member state. But if we are claiming the right to equal treatment, dus gelijke behandeling, then we're looking at Article 24, paragraph 1 of the Citizens' Right Directive. It's actually elaborated on this article. And we're looking if we can actually be able to, we need to have the rules, we need to met the rules on the rights of residents. And we need to look at Article 6, 7 and 16 then of the Citizens' Right Directive. And why do we need to look at these three articles? Because Article 6 is about what we need to have when we're dealing with someone who's less than 3 months in a member state. And what we just saw, we're actually in the same slide. We only need a passport and health insurance. So with 7, we're dealing already with someone who's there between 3 months and 5 years. And we need you to be a worker or self-employed or to have sufficient resources. And I just forgot to mention that about the sufficient resources, it's also important to not only be able to take care of yourself, but also of your family members that are with you. So that's something really important to note with the sufficient resources. If you're only able to take care of yourself, that is not enough. And when we're looking at Article 16 of the Citizens' Right Directive, we're actually looking at someone who's more than 5 years permanent resident somewhere in a certain member state. So we actually need to look at, okay, can we met the rules of the rights of residents? Because if we can met those rules, then we also have the right to claim equal treatment. Otherwise, we don't have the right to claim equal treatment. And it might be a little bit vague for you what we mean with equal treatment, but when we talk about claiming your right of equal treatment, we're talking about also want to have some sort of loan or grant. So I'll say it in Dutch also. Dus als we kijken naar, oké, we hebben de right of residence, dus het verblijfsrecht. En we hebben de right to equal treatment, dus het recht op gelijke behandeling. Dan kijken we dus eigenlijk, bij gelijke behandeling kunnen wij voldoen aan die voorwaarden uit de right of residence, dus die verblijfsrechten. Want als jij kan voldoen aan inderdaad een paspoort, een health insurance, bij bijvoorbeeld onder de 3 maanden, dan heb jij dus ook het recht op gelijke behandeling. En als we het hebben over claimen van gelijke behandeling, dan hebben we het over claimen van een toeslag, een toelage. Dat je waarschijnlijk gebruik gaat maken van de social benefits. Dat is waar we het dan een beetje over hebben als we het hebben over equal treatment. Dus hebben we het over iemand die een toelage gaat vragen, dan is jij aan het claimen op de grond van equal treatment. Hebben we het over iemand verblijfsrechten, dan hebben we het natuurlijk over de right of residence. Maar om te kijken of je equal treatment erop mag beroepen, moet je dus kijken of je kan voldoen aan die regels van de right of residence. Dus dat is even een beetje iets wat je in je hoofd even moet begrijpen. Om aan equal treatment te voldoen, moeten we voldoen aan de right of residence. Maar we zitten wel in artikel 24, paragraaf 1, maar we gaan dus wel 6, 7 en 16 af. Dus dat even voor dit stukje. We are talking with equal treatment about social benefits, so about loans and grants. So that's that for the which right is being claimed. And then we're going to the last bit. It's about the justification ground, about the restriction the member state can actually justify if they are not allowing you to stay there or have equal treatment. So we have looked at what right is being invoked. We looked, are we dealing with residents or are we dealing with equal treatment? And first, the restriction on the right of residence. So a member state can say, no, you're not allowed to be a resident here on the following grounds. And I will just zoom in really quickly again. You're not allowed to stay on grounds, and we're looking at 27, paragraph 1 of the Citizens' Right Directive. Grounds of public policy, public security and public health. But paragraph 2 also states that it needs to be proportionate and based exclusively, so only on personal conduct of the individual concerned. And the conduct, we mean, I will say it in Dutch, gedrag. Dus het mag alleen gebaseerd zijn op het gedrag van de persoon in kwestie. Dat is wel echt even een belangrijke. Dus highlight dat ook even in die artikel 27, paragraaf 2. Only based on the personal conduct of the individual concerned. Paragraph 2 also states that if we're talking about expulsion in the case of permanent residence, we can only have a restriction if we have serious grounds of public security or public policy. So it needs to be a little bit more extreme than only a reason of public policy. We need to have serious grounds. And Article 28, paragraph 3 takes it even a little bit further, a little step further, because if we're talking about an expulsion in the case of a residence for 10 years, then we really need to have imperative grounds of public security. And imperative grounds, we're talking about dwingende redenen. Dus in het Nederlands is dat dwingende redenen. So I will also just explain this a little bit in Dutch. Dus als we echt in het begin kijken, oké, we kijken naar de restricties op het recht van residence, dus verblijven. In principe kan het gebaseerd op public policy, security en health. En dan moet het dus proportioneel zijn en alleen gebaseerd zijn op iemands gedrag. Dus echt het gedrag van die individuele persoon. En dan als we kijken naar iemand die er dus al 5 jaar is of langer, dan moeten we echt ernstige redenen hebben. Dus in het geval van permanent residence, we hebben echt ernstige redenen nodig. Gaan we nog een stapje verder, iemand die er 10 jaar of langer is, dan hebben we dwingende redenen nodig. En wat zijn nou dwingende redenen? Nou, dan kun je echt gaan denken aan terrorisme of drugshandel of mensensmokkel. Echt hele ernstige redenen. Eigenlijk moet ik zeggen hele dwingende redenen, want anders kom je in verwarring met de serious grounds. But if we're talking about imperative grounds, we're really talking about things like terrorism or dealing drugs on really big scale. So it are really heavy grounds. You cannot expel someone really easy if they are there for already 10 years. So then we're going to look at the restrictions on the right of equal treatment as the last thing we will do, and then the recap, of course. Article 24 and then paragraph 2 of the CRD, because we're dealing with equal treatment, we're dealing with the social benefits. Social assistance can be denied in the first 3 months based on Article 6 of the CRD. That's just really easy. Okay, you're there less than 3 months, then we can deny you the right of the social benefits because you're there for such a short time. But if you're residing there for a longer time, but less than 5 years, the state is not obliged, so niet verplicht, to pay study grants, except in a few cases. If we're talking about workers, self-employed workers, dus ZZP'ers, persons who retain such states, dus mensen die eigenlijk een beetje ze zijn geen werker, maar voor gemiddeld gezien worden ze nog onder werker geschaard. Dus iemand die bijvoorbeeld werkloos is geworden of arbeidsongeschikt is geworden, dat zien we in artikel 7 van de Citizens' Right Directive. So persons who retain such states is like someone who can't work anymore because they're sick or something, or they're just in between jobs. And we look at article 7 of the Citizens' Right Directive just to see, okay, are they in such states? Member of their families, or you have been a worker or self-employed, article 7, paragraph 3 of the CRD. So you're residing there less than 5 years. The state is not obliged, not verplicht, ze hoeven het niet te doen. They don't need you to pay a study grant, except workers, self-employed persons who retain such states, article 7, members of their families, and you have been a worker or self-employed, but you have to meet article 7, paragraph 3 of the CRD. So, a little recap of this video. We talked about the right of residence, article 20 of the TFEU. We talked about the Citizens' Right Directive. We talked about article 20, that we're using that if we're talking about third country nationals who, well, we're probably dealing with the case that there's a child with EU citizenship, but the parent needs to leave the EU because they do not have that EU citizenship. We need to look at the dependency of the child on the specific parent, so that's from Chavez-Vilchez. We do not need a cross-border element if we're dealing with article 20, and Chavez-Vilchez is a really important case, so really memorize that one and highlight the important parts. If we're dealing with European citizenship, article 21, and we're also dealing with migrant non-economically active persons, then we do need a cross-border element, so we need someone to go from A to B. It's a lex specialis, the CRD, so it's actually extending the rights of article 21. And we can invoke or the right of residence or the right of equal treatment, but with the right of equal treatment, we see actually that we need to meet the rules. We need to meet the rules of the right of residence. And then we're looking at article 6, 7 and 16 of the Citizens' Right Directive. So we need to meet those rules. That is it for this video, and I thank you for watching. See you in the next video.